All right. Good afternoon, McGraw Hill Education. How are you? Great. Broadcasting live from a packed house here at 2 Penn Plaza. We've got about 160 folks signed up for this first session. I wanted to introduce to you, with no further ado, we have one of the country's best estate lawyers here, Jonathan Blattmachr, joining us here from New York City. Today he's going to talk about estate planning, wills, but most importantly, answer those questions about why and how to get started. So with no further ado, Jonathan.
Matt, thank you very much. It is a pleasure to be here with you today. Love these intimate groups, and it's a delight for me to be here. What is estate planning? Well, estate planning really consists of, in a broad sense, a couple of things. One, it's the protection and building of wealth during lifetime, and it also involves the orderly and efficient transmission of assets at death. It's really a subset of financial planning, which is a very, very broad category of things, not just investments, but the transmission of wealth, protecting yourself against claims of creditors, and especially the biggest creditor of all. Who knows what's the biggest creditor most people ever face? It's your spouse in the event of a divorce. Also, the Internal Revenue Service is up there pretty high as well. It's not just planning for the transmission at death. And as with all aspects of financial planning, things can get very complicated, and you're going to need at some time some professional advice. Why is this important to you? Whatever you have, whatever you've built, you want to protect. You don't want to have it foolishly go away. One of the ways that I was able to get really crotchety old men to do planning, especially if they had a daughter, was to ask, how would you feel if the inheritance your daughter receives from you winds up going to me in a divorce or when she dies? And then I give it to my next girlfriend or boyfriend or the children from my prior marriage. And all of them instantly say they want to do it. Same thing will apply to you. I was someone in here before. We were talking about what would happen if she passed on. She's a young woman, but she doesn't have a will. So, and it's not just about the money. You ought to think about what's the most important thing you can leave your family. And it's probably something like being a good person, doing something for the community, not being selfish. I've never known anyone, no matter how wealthy they are, who said, what I want is for my children to be able to leave idle and just ridiculously frivolous lives. As Warren Buffett said, I want my children to inherit enough money that they can afford to do anything, but not so much that they can afford to do nothing. And that's something to really think about, what you really leave. What financial goals do you have for yourself? Well, you want to maintain or improve your current lifestyle, probably. You want to pay or save for your descendants' education. You may want to provide for a lifestyle during retirement. We're going to spend a lot of time talking about retirement because for everybody in this room, you look all very young. But even if you're relatively near retirement, it's an important thing to consider. You may want to pay to maintain something for your parents, for example. And one of the issues, if you have older parents, is what happens when they're no longer able to take care of themselves and you're facing the prospect of incurring expense for a nursing home. You also, as I said, want to protect your assets from claims of creditors, including of the government. And you don't have to worry about estate or inheritance taxes now unless if you're single, you've got more than $5.5 million, or if you're married, you have more than $11 million. And I'm not so sure many of you in this room or many people on my block have to worry about estate tax anymore. Now, today, New Jersey has a lower exemption and New York has a lower exemption. Those are both being changed. So you really don't have to worry about it unless you become one of the uber-rich folks around. And Matt, we are now, here we go. Failing to plan is planning to fail. I want you to keep that in mind. Failing to plan is planning to fail. Your planning has to be comprehensive. You've got to plan for your own incapacity, and that will involve the management of your affairs while you're during some period of incapacity and planning for the disposition of your wealth when you die, and the financial planning to pay for your expenses during retirement and pay for expenses while you're incapacitated and can no longer work. Okay, let's see if we can move this along, Matt. We seem to be stuck. Here we go. Now, as I said, this is an enormous area. And we could spend, honestly, a week or a month on each of these. We're going to talk about three things. One, protecting wealth in the event of incapacity, disability. That's your wealth, your spouse's wealth, your parents' wealth. It's something we need to talk about. And that involves two things. One is elder abuse. The amount of elder abuse where older people are taken advantage of, both physically and financially, is rampant throughout this country. It's a horrible thing. In fact, the New York State Legislature just changed the form of the power of attorney to try to reduce the amount of elder abuse. It's so great in a financial sense. You also have to worry about nursing home costs, and we're going to go through that a little bit in detail. Planning for the orderly and efficient transmission of assets and wealth, and then planning for retirement. We're going to try to cover all of those, and that's just part of what you do with financial planning, and we don't have time to even go into any of these in real depth. There are about 6 million people in the United States who are 85 or older. By 2050, that's almost going to be 20 million people, and half of them, once you get to age 85, are going to have some sort of cognitive impairment. So you've got to plan that for your mom, for your dad, for your spouse, for yourself. And you can't just do it with a power of attorney. Even the so-called durable power of attorney is not going to be sufficient. And keep in mind, if you're married, when your spouse becomes basically incapacitated, you're going to become a caregiver. Or your mom becomes, and it's a big thing. And by the way, companies worry about this all the time because employees have to spend a tremendous amount of time. The way to reduce the amount of time that you have to put in taking care of your decrepit mom or dad or your husband or your wife, you've got to start planning relatively early. In fact, the largest financial threat to a financial plan is long-term care expenses. And for a couple turning age 65, there's a 70% chance that at least one of them is going to need long-term care. Isn't that remarkable? That at least, half of them are going to, a 70% chance that at least one of them, and very often it winds up to be two as they get older. 60% of people over the age of 75 need long-term care, and the average stay in a facility is 3 years. What's the cost? Well, assisted living, just going into an assisted living facility, $53,000 a year. These are very, very conservative. By the way, in this area of the country, it's higher. Nursing home facility, $78,000 a year. In this area, over $100,000. A home care aide for just one shift is about $45,000. Around here, it's in the neighborhood of $60,000 for every year. So if you just have that 3-year period and you say, I'll keep mom in her home, you're talking about probably something in the neighborhood of $150,000 to $200,000. And the longer she lives, the more it's going to cost you. You've got to plan for chronic illnesses. There are certain things that can be done, TRICARE, Medicaid, traditional forms of insurance, asset protection planning. You can get public benefits for these things, but under Medicaid, you have a 5-year look back because people say, well, look, I know how to protect my assets so that it doesn't all go to the state of New York or New Jersey or Connecticut when I go into a nursing home or my mom does. Jonathan told me there's a $5.5 million exemption from estate and gift taxes, so I'll just have my mom give away all of her money to me and then we can put her in a nursing home. There's a 5-year look back period. So if you wait until mom is ready to go into the nursing home and you think you can just give the assets away, you're very, very mistaken. Now, there are a lot of things you can do, but the time to do it is now. The time to plan for it is now. By the way, if you're a veteran, there are special benefits you can get, but one of the things you've got to talk about is who is going to have the authority to plan. So you've got to put yourself in a position that if your mom or your dad or your husband or your wife is not in a position to do it and it falls on you, what gives you the authority to do it? Just because you're a child, just because you're a spouse doesn't give you the authority under the law to do it. You're going to have to become an agent, basically an attorney, in fact, and a few other things as well. Okay, Matt, we're again a little bit stuck here. Cost of waiting, no one is going to know how long it's going to be, when it should start, but you're going to have many more options if you do it in advance. Private payment, these are self-pay plans. In 78% of the cases, the family winds up paying for it, and there are ways in which you can reduce that and take you out of it. There's long-term care insurance. Is it a good idea? Is it a bad idea? Well, it's a little like buying life insurance, and you say, how long should I hold my life insurance for? Is it a good purchase? You got to tell me when you're going to die, and I can tell you. The best investment you can make in America is buy a policy of insurance, walk out of the agent's office, and be run over by a truck. The return is enormous. But it all depends on when you die, and whether long-term care is good or not depends when you have to go into a nursing home and how long that will lay. Government will pay, but there are limitations as to how much income the patient can have and how much she can have in the way of assets. Right now, you can only have income of $733 a month. By the way, that includes Social Security. And many of you who have parents who have Social Security are going to be received more than that. And basically what happens, everything above that $733 is going to go back to the state to pay for the nursing home care. In addition, there's an asset limit, which is only $2,000 or for a married couple, $3,000 in total. That means you have almost nothing. But there are so many exceptions and special rules. For example, a home in which you live in or a dependent of yours lives in doesn't count against that $2,000 or $3,000 limitation. Similarly, you can have certain annuity products. You can have life insurance products. You can also have a burial plan. And what you need to do if you're serious about this is get to a so-called elder law attorney and talk to that person well before the time mom is going into the nursing home. But even if mom is now in the way to the nursing home, go see that elder law attorney, and that attorney probably could salvage a tremendous amount of the wealth for the family. There is that 5-year look back. Any gift made, unless it falls under an exception, or any transfer made, unless it's for full valued within 5 years of when you go into the nursing home, will basically be clawed back by the state to reimburse itself for it. This is a very complicated area. If you get on it early, you can save your family a tremendous amount of money. It's very important. Get professional advice and get it early. There's a tremendous amount of information that's out there on the Internet. It's all for free. In fact, the government even gives you information about it, but ultimately you're going to have to go to a professional, basically an elder law attorney. Disposition of assets to death. There are basically 3 ways. One is through trusts. Now, I'm the most pro-trust lawyer in the world. I love them. My family, we have 14. Drives my wife crazy. But there's a reason for everyone, and a properly drafted trust, and I'll get into this a little bit more, can save you a tremendous amount of money and heartache. The other thing is wills, but wills only dispose of assets which you own at the time you die. For example, you have a life insurance policy, it's by the designation of a beneficiary in the form. You have an IRA, a pension plan, a 401k plan, that's by a designation of a beneficiary. Similarly, if you have an annuity, you will designate a beneficiary. It will not be disposed of by your will. So you need to think about all those things on how assets are going to be. Now, what documents does everybody need? And there's often much more. Number one, you need a living will. A living will doesn't dispose of property. It says what you want to happen basically if you are incapable of making medical decisions for yourself and you're probably not going to recover. If you are brain dead, you can incur tens of thousands, hundreds of thousands of dollars as they keep you alive. But under laws of all states now, you can say, I basically want the life support turned off. You can make it very detailed or not detailed at all, but make it your decision. Don't leave it up to your spouse to say, well, I think she'd want the plug pulled. Or you have 2 children who are fighting. Keep mom alive no matter what. Even if all the money is spent and the other one says, let her go. She wants to go that way. This allows you to decide what you want to happen when you're incapable of making your final decisions. You also need a health care or medical power of attorney. That's where, for example, you're in an accident, you're unconscious, and they want to know, should they give you a transfusion? Or as Matt worries about, a brain transplant. Should Matt get the brain transplant or not? Well, the kids will fight about it, his wife will fight, but he can name one person, and only one person in most states, who makes that decision. Why do we not want 2 people to make a decision? as they may disagree. So we want one person. Typically, it will be your spouse. But as I'm going to talk about later, if you get separated or divorced, you better change, because your biggest enemy in the world may be your ex-spouse. In fact, the New York Times, let me tell you, it's a true story. The New York Times a few years ago had an article in which it reported the results of a special poll that it took among people. And one of the interesting questions they asked is, do you know someone whom you're personally certain will go to hell when that person dies? 22% of the people said they did, unless they'd been divorced, and then it was 55%, okay? So you think about that. You are also going to need a financial power of attorney, and it's durable because it will survive your incapacity. So you name your spouse as your attorney in fact, or your brother, or your child if she's an adult, and they can make the financial decisions if you're incapable of making them. Now, by the way, this is important to have, but I want to tell you there are limitations, because very often banks, insurance companies, even the employer doesn't want to deal with it. So, well, how do we know it hasn't been revoked? How do we know she's still alive? So you have to have it, but there are better ways to cover it, and we'll talk about it. And the final thing you're going to need is a will. You need a living will, saying what you want to happen if you become basically brain dead. A health care power of attorney, so someone can make the decision, are we going to cut off your fingers? Are we going to give you the heart transplant? A durable financial power of attorney, and we also need a will. Yes. Yeah, the medical. Yeah, the question was, is the durable medical the same as health care? And the answer is yes. These are health care or medical power of attorney. Now, when you have that medical power of attorney, if you have it, it's written. You can have a living will, medical power of attorney. If you don't have anything, you're going to have to go to court. And that means only the lawyers get paid for it. And it's very expensive, and it's also a matter of public record. So, and you don't want that. You don't want to go in and say, gee, we think mom is crazy now, she needs it. You really don't want it, and you have to make a lot of reports, so please make sure you have one. A financial power of attorney, you have to have capacity when you give it, but it can go away. There's a fiduciary relationship between you and the agent or attorney, in fact, as known. You don't have to post a bond. You can waive the right for the attorney, in fact, to say what happened with your assets. If you don't have a power of attorney, again, you got to wait till you go to court. You're going to spend a lot of money. There's going to be bonds which are going to cost money. There are limitations. And you also have problems as to whether or not that's going to be recognized by another state. So it may be that you live in New Jersey and you get a court order for New Jersey, but if your guardian has to go to New York to deal with something like maybe J.P. Morgan Chase right here, you're going to find that there are limitations as to how much they will actually agree to follow it. Why do you need a will? Well, one thing, if you don't have a will, the state will decide what's going to happen to your property. So the one I was talking to before is from New Jersey. Chris Christie in the New Jersey legislature is going to decide what happens to her property. And the will not only controls where the property passes, but it allows you to control how it passes and by whom your assets will be managed. Very, very important. You get to name the person who will execute your estate plan. That person is called an executor, the one who executes that plan. Don't you want to decide that rather than having some judge decide that? Your executor has tremendous power even over assets that don't pass under the will, because he or she is going to be the one who deals with all the creditors and also going to deal with the Internal Revenue Service. Also, you can make sure that you're going to reduce the risks of fights over your wealth and its disposition. And in fact, even if you have an even-Steven disposition of your wealth, it's going half to your daughter and half to your son. Don't be surprised if there aren't fights. As I've often said, you never know another person until you share an inheritance with them. And it's really true. And I've been there personally. And it's sometimes kind of an ugly thing. I told you I'm the most pro-trust lawyer in the world. Trusts are extremely important. We're going to talk a little bit about this, but they are grossly underused. One other thing. Anybody here have any children who are minors? Do you want Chris Christie to decide who's going to be the guardian? Or do you want to decide who's going to be the guardian? That's one of the things you can control in your will. By the way, a little bit of advice. Very often you say, well, let's name my brother and his wife as the guardians. They love our kids. We've spoken to them. It's terrific. But what happens if your brother and his wife get divorced? So what I would recommend, if you're using a blood relative, name only that blood relative. Don't say, you know, George and Janet, your brother George and your sister-in-law Janet. Now, obviously, if George becomes the guardian, and Janet may have a major role in rearing your child. But make that decision, and one thing, talk to the people whom you've named as the guardians of your children. Very low risk that that you're going to die before your kids are 18 years of age with no surviving parent, but it does happen from time to time. Make sure you make the right selection, but please speak to them ahead of time. I know Matt told me his children are the most wonderful thing that's ever happened in this world since the beginning of time, but I'm not sure the people who are stuck with those little SOBs are going to feel the same way. So, again, talk to them ahead of time that they are willing to take on that responsibility. You lower the risk. This is should you irrevocable trust? Oh, what happened here? Did we go on? Oh yeah, why everybody needs irrevocable trust. These are sometimes called living trusts, and these can completely be revoked or amended at any time. Why should you have one? It's a written document for your own benefit or for you and your spouse sometimes. It lowers the risk of elder abuse, because now you have a trustee, and the ability to get the money means you have to deal with a third party. So it can be very, very effective to reduce elder abuse. Typically, it has no tax effect during lifetime. It disposes of assets at death in a way similar to a will. It will allow much easier administration of your assets if you suffer a cognitive impairment. And I'm not kidding. The difference between this and acting under a power of attorney is enormous. Because if you provide that when you're 80 or right now, your brother, your son, your daughter is going to be the successor or a co-trustee, you're not going to have any problem with any bank, any insurance company anyway, once you show them the trust instrument. Much easier if that. I mean, that will pay for itself many, many times over if you become impaired. And remember, if you're 85 years or older, there's a 50% chance you're going to be impaired. Less resistance dealing with financial institutions. It avoids the probate process. Very often when you die, you wind up going to court, and there's a tremendous delay in having your assets pass through what they call the probate process. You avoid that to the extent the assets have been put into a revocable trust. It's also less likely that the disposition of your wealth is going to be attacked, because you lived with this instrument for years and years. Your will has no effect until you die. So the chance, and this has been borne out by the statistics, the chance of having a will contest goes down markedly if you have a revocable trust. Believe it or not, it can help void state income tax once you die. The bad part is the setup is much more complicated. You've got to pay a lawyer. Don't do it on your own to do your revocable trust. And then you have to transfer all of the titles to your assets over to that trust. Your home, your bank accounts, your stock account, and so on and so forth. Now, it might be Jonathan Blattmachr as trustee of the Jonathan Blattmachr Revocable Trust, or Jonathan and Betsy Blattmachr as trustees of the Jonathan and Betsy Blattmachr Revocable Trust, whatever name you put on it. But you have to transfer ownership, and that takes time. And if you don't do it, you're not getting the benefit of it. But long term, it will save you money, especially if you have a cognitive impairment, even for a temporary period, and certainly when you go to your ward. What else do you need? Make sure that the designations on life insurance are there. Make sure your designations on your retirement plans, like your 401k, are exactly as you want it. By the way, if you do one that's other than my husband, George, if he dies, my 2 kids or whatever it is, you should show it to the plan administrator to make sure they'll accept it. My designations, because I use trusts, are very, very complicated, and I often get resistance. Even in my own law firm, even though I was the head of the Trust and Estates Department, our plan administrator came and said, "You can't do it this way." I said, "Oh, really? We've never seen anything like that." And they said, "Well, get used to it. That's the way I want it." But you should go to your administrator ahead of time to make sure. Now, if you are divorced, or you think you may become divorced, you better make sure that your former spouse is out. I don't know how many times people have, I'm leaving my estate to my husband. He's named the beneficiary of my life insurance policy, my 401k, everything I own. You get divorced and you don't change it. Now, if you die, you can make absolutely sure that he's going to come back in and say, it all belongs to me. Most states have your spouse go out of a will, but not with respect to these other documents. And most of your wealth probably will not be transmitted by your will, but by beneficiary designations, like life insurance and like pension plan designations, or bank accounts that are sometimes in joint name or in trust for accounts or similar things like that. If you're married and you know you love your spouse, you've been married for 40 years, he finally dies and you've inherited, or you die and he inherits, you've got to remember that there may be a remarriage. And no matter what promises have been made in your bedroom during the marriage, you can bet your bottom dollar that when the new guy or the new gal comes along, basically their loyalties will change. I've seen it happen over and over again. Remember, you are most influenced by the person with whom you sleep. So when your wife or husband remarries or gets a boyfriend or a girlfriend, you can bet your bottom dollar they're going to be influenced by that person. And you're going to have to be very, very careful and that diligent. And that means you better leave whatever you have for your spouse in trust. Because really, seriously, do you want the property which you've left to your husband to go to his next wife or her kids? No, you don't want that. The only way to ensure that it's going to go to your kids is to ensure that you have it in trust. And you might say, well, I have such little money, what does it matter? I don't care how little you have, you really should seriously think about a trust. Now, if you have grandchildren, consider a trust because, again, I die, I leave it to my son, John. John dies, he leaves it to his wife, Stephanie. Now, my son has been divorced. He has a child from a prior marriage. Stephanie, his new wife, loves my older granddaughter like her own, but over time that might change. If I want to be sure that my granddaughter Mia gets her fair share, I've got to put it in trust for him. In addition, if John leaves it to Stephanie and she remarries again, her affiliation, her loyalty will change to her new husband, so as it is. By the way, make a list of all your financial interests and assets, including any expectancy that you might receive from another relative. Have that available. It's a great thing, and it will save a lot of time if something happens to you, including if you become disabled. Retirement planning. Have to care. Do you need to plan for your retirement? What do you think? Just let it go? Well, of course, unless you want your golden years to be, your most pitiful ones. When should you start planning for your retirement? The answer is, if you have to ask a question, you got an impairment, I'm telling you. The answer is yesterday. That's when you should start. But if you haven't started, it's right now. It is never, I'll start planning for my retirement tomorrow, next week. I got a car payment. I got to go on vacation, whatever it is. You don't want to do it. By the way, health care. Warren Buffett said, a spectrum much more sensitive than corporate taxes, which we hear about all the time, now how our health care costs. Chief executives who have been maniacally focused on seeking relief from the tax bills would be smart to shift their attention to these costs, which are swelling and swallowing their profits. That's also true for you. Keys to financial planning, the thing is start early, get compounding working in your favor. Here's Albert Einstein. Albert Einstein said two things we have to do. Number one, compounding is the most important thing in the universe. He really said that. And you want to start early so you get long-term compounding. And and this is just a difference of what you get. Which line do you want to be on? You obviously want to be on this line, which means you want high compounding over a long period of time. That's what you want. That's Einstein's right. Second thing he said, the hardest thing in the world to understand is the income tax. He really said that as well. And here's just an example of what taxation does to your wealth. If you're lucky enough to earn 20% a year over 20 years and you pay a 40% income tax on your returns, 75% of your wealth will have been eroded by taxes. Wow, what a difference. And what that means for you is that, this is the most important thing in the world is tax-free compounding, is this is the difference of what happens if you start at 25 or 35 to save for your retirement. Look how much more you have. and how much you're going to have to do. But you want to absolutely start as early as you can and use your tax-exempt entities. Don't buy municipal bonds. The yield is too low. But if the company has a 401k, maximize it. Oh, I know it hurts, but I've got expenses. Maximize it as early in life as possible. Absolutely critical. And by the way, I tell this to my clients, well before your retirement, spend 1 year living on what you think is your retirement income and see how well you do. Now, some of your expenses will go down, like commuting expenses perhaps, and, and not these $1,500 suits that Matt buys, but you may have other expenses actually go up. By the way, here's a bit of advice. If you can afford it and you're in good health, don't take your Social Security until age 70. If you take it at age 70 as opposed to 68, you'll get 32% more each and every year for the rest of your life. Very, very important. Very, very important to do. Summary and conclusions. Planning is essential. Make sure you have an up-to-date will, perhaps a revocable trust, a living will, power of attorney. Start saving for retirement now. Work with professionals, lawyers, CPAs, CFPs. Don't do your own brain surgery. And the most important factors in building wealth is long-term tax-free compounding. We could have spent a day on each of these topics. So thank you very much. Any questions? Yes. Right. The question is there a way to calculate what you're going to need for medical expenses? Well, it is in part a guess on your own health. I mean, when you turn 65, all of you, because you've been working, will get Medicare, which I'm on, which is a pretty good program. There is that, quote, donut hole, and my wife and I have an AARP supplement, which you need to look at. And there are limitations. And again, you may want to do some things to reduce the risk of the state taking money. They're not going to deny you basic critical health care needs, but you don't want to spend it. So make sure you get your medical care, your Medicaid, if you're at your Medicare, but also have a supplement which seems to work best for you and for your family. What's the difference between a revocable and an irrevocable trust? A revocable one is one that you can change, revoke, take the assets out entirely on your own. It doesn't result in a completed gift. An irrevocable trust is one which, in theory, you cannot revoke or change. Now, I got some statutes passed in most states now that allow you to do some modifications even to an irrevocable trust. What I was talking about is a revocable trust, which is for your benefit or you and your spouse to manage your assets during your lifetime, especially in the time of disability, or to transmit the assets when you die without being forced into the probate process. There are some states like California, Michigan, and Texas, and Florida where they are used extensively. For some bizarre historic reasons, they are not used as extensively in New York, although it's growing. And I'm going to tell you that the revocable trust, if you get it well drafted, and if you'll take the time to fund it, which is a pain in the patootie, in the long run, it will save you a tremendous amount of heartache, and it will save you and your family a tremendous amount of money. But you're going to have to go to an attorney in order to get one. It's just you have to go in and you have to go to the bank and get everything changed, your stock account, title to your home. By the way, even if you transmit it, they can't call your mortgage loan due merely because you've transferred it. There's a federal law to that effect. But again, I'm urging you, wealthy people that I've represented do a lot better when they hire good professionals. And even though, those wealthy people, it's almost nothing to them expense, get yourself an attorney, an accountant, a certified financial planner who can work with you. It'll cost you a little bit of money, but it will pay big dividends in the long run. What's the ballpark for creating a revocable trust? Well, it probably will run anywhere from $500 to $2,500, depending upon what you want and how proficient the lawyer is in doing it. A lot of it is being prepared. If you read up about revocable trusts, you know what you want. You can go to the attorney. There are now drafting systems available to attorneys. I do one for attorneys. I have 2,000 lawyers in America that do it, and they're able to do like a complex will and revocable trust both in under 10 minutes. So they'll talk to you, they can do the documents, and you'll probably be out of there with under $1,000 of expense. Can't guarantee that, but that's it. Now you can go to LegalZoom has trusts on it, Rocket Lawyer has on it, and it's probably better than nothing, but I urge you to at least talk to a professional. Maybe you have a cousin, a friend from college who's in this business, and you can talk to that person and get a little bit of advice for free. But at the end of the day, do have a professional give you some guidance. The question was, is my law firm involved with what McGraw Hill? I am now retired from the active practice of law, so, I was retired for advanced age. I got 65, and the firm said you're no longer competent. So, you're out of, even though I write 2 law books and I make, I've made thousands of lectures in my life and so on. I've testified before the Congress. I've written over 100 laws, many of which are in estate planning. But they said, no, you're not competent anymore. So the answer is no, but I'm not. But Matt and Mike can give you some guidance, and there is a plan for you, which I guess is covered by the company. You pay into that. Well, let me tell you, if you want to know the best mechanic in your town, don't ask other people who own cars. Ask other mechanics. And so if you want to get a really good lawyer, call a lawyer and say, in addition to you, give me the name of 2 other really good lawyers in this field. And yes, professional jealousy will rear its ugly head, but if you do it a few times, you're going to get a relatively short list. That Joan Smith or Harry Brown are on the top of the list, and you can call them. That's the way you find the best. Go to other professionals in the field. Okay, well, then Matt is going to tell you who's the best on it. Okay, she asked, would it be covered by, what pay in? And the answer, Matt said, is yes, except to the extent of the deductible, which probably isn't more than $10,000, is it? But it probably wouldn't ever exceed more than $10,000, right? Right. A revocable or revocable trust. You're the trustee, but here's what you typically should have in it. This is a trust for my benefit. I'm the trustee. But if a doctor, one of my doctors, saying I am suffering some ability to manage my financial affairs, then my son, my daughter, my brother, the local bank will become the trustee. So if you're having an impairment, you just go to your doctor and say, tell us that Marilyn is now doesn't mean you're incompetent, but she's suffering some inability to manage her financial affairs. Don't have to go to court. The doctor does it. Now your son or whoever goes in. And if you're still competent, you can just say, I want you to take over. So you do that by a writing. So that's it. But you're in charge of it. It's completely revocable, changeable by you, except if you really become incompetent, it can't be changed. But do you designate someone to take over in the event that you're incapable? Yes, you do. You put in, I'm the trustee, but if I become impaired or when I die, it will be, and you'll have more than one successor there. Yeah, I had a slide up there saying whether you should transfer funds into a Roth IRA makes sense or not depends upon factors. I came up with a list of 17, but the major one is what are the future tax rates going to be? Like when they first allowed this, the tax rates, it's the rates, but it could be the law. So again, it's very, very hard to know. But if you're in a Roth IRA, which means like a regular IRA, it grows tax-free, but also you can take it out tax-free. And that's a tremendous benefit if it's in a Roth IRA. But if you have a taxable account something that will be taxable when it comes out, like a 401k or a traditional IRA, then you can convert it to a Roth, but you have to pay income tax on the amount you convert. And does that make sense or not? Very, very hard to know, because one thing I can guarantee to you, the law will change. The tax law will change. So it's very, very hard to know. I have not done it, at least not yet. If Donald Trump really gets tax rates down to 15%, I'd have been nuts to do the conversion previously. But I'm not sure we're ever going to get to 15%. It did get down to 28% under Ronald Reagan, but it hasn't been that low again since 1987. Any other comments or questions? Let me hand it over to Matt.
Thanks, everybody, for attending. I wanted to point out to you a company resource that's provided for you. Your HR department would like to let you know about liveandworkwell.com. This is a service provided through one of United Healthcare subsidiaries for all McGraw-Hill Education employees using the code MHE, capital letters MHE. At the site liveandworkwell.com, you can actually go on and create popular legal documents, wills, living trusts, powers of attorneys. This is all provided for you as part of your employee benefits. So you select your state in the drop-down, and you can pick from a variety of options. I will tell you, I sat at lunch yesterday. I completed a full personal will in 30 minutes while I ate my sandwich and answered questions from my colleagues who stood behind me. It's a very powerful tool. It works with a questionnaire system. So it asks Matthew, who's your wife, Kristen, kids' names, who do you want to leave money to. It also gives you money. I could lift money to my pet. So there's a lot of powerful tools, but it's all built through, again, this is Live and Work Well, done through United Healthcare. The code is capital MHE. So I encourage everybody to use that. It's a great tool. Next step for you, for your company resources, if you have questions, as you guys know, you have a no-cost certified financial planner available for you for all MHE employees only and your spouses to ask questions in a 30-minute one-on-one session. I have my will. How do I handle it? I've got a 401k outstanding. I have an issue with a previous spouse, whatever it may be. You can go online at this website right here. All employees can book no-cost time with a certified financial planner. Just a quick reminder, you may have heard me say this before, every employee also gets a no-cost subscription to LifeLock to monitor your credit and good name. Every single employee should be taking advantage of that. Also, no cost for all employees while you're employed here. So I encourage you to visit the website here. There's a scheduling tool. Click Schedule Now, and you can book time with a certified financial planner. There's nothing for sale. We don't sell anything. This is paid for by your employer to help you with those financial questions. And if you have any questions for Mr. Blattmachr after this, you can email us directly on this site here, or you can respond to your invitation. It's mhe@mcgrawhillfcu.org. When you receive your confirmation email, please feel free to respond to that with your questions, and Mr. Blattmachr will actually answer those for you, and we'll get back to you via email. So thank you so much for attending. This session will be recorded, and we'll be sending out the slides after the 3:45 session. So thanks so much.